Good evening, everyone.
Good evening.
Thank you. I want to welcome you all to the sixth and sadly the final, but triumphantly the final Baltimore History Evening of 2025, sponsored by the Baltimore City Historical Society. And what's exciting about this, not just the talk tonight, but the fact is this was the first year since the pandemic we came back and we convened in person, and you're one example of that. So I'm glad you're all here. And we're here at the Village Learning Place, which has been our host for many, many years, and as always, we're grateful to them for hosting. And we will have another series, 2026, starting in January. It'll be very exciting, but for those of you who can't wait that long, in October we'll have a History Honors event. And at the History Honors event, we will honor contemporary and past makers of Baltimore City history, as well as people who've written about Baltimore City history. So if you come, you have a chance to rub elbows with history makers and history writers. And you'll get notice about this event if you're on our contact list now. And if you're not on our contact list, make sure you sign in on the sign-in sheet. We'll put you on the contact list, and you'll be one of the first people to know about this event, which is a really nice event. Also, if by some chance you're here and you haven't signed in on the sign-in sheet, please do that, because one of the things we ask you is how you heard about this event, and that helps us with our publicity for next year. And one other thing I'd say about the Baltimore City Historical Society is we're a group of volunteers. This is a low-budget operation, so we're always appreciative of contributions, even small contributions. And if you look on your seats, there's this white sheet of paper with a QR code on it. And if you take your smartphone and hover it over the QR code, it will take you to a web page where you can make even a very small contribution. So in your excitement at the end of the talk this evening, when you say, gee, I'd really like to support that, take that inclination seriously. Take the piece of paper home with you, and in the leisure of your home, act on the impulse to contribute, even if it's a small amount. We appreciate that, and we know you support these activities. That said, let me talk about this evening's talk. This evening we have Michael Casiano, who has the most complex talk title of any of them in the series. So it's suitable that he's the culmination of the series. And I know you can read, but let's read it together. It's I Ask Mercy in Your Hands, Henry Alfred Brown, Third-Degree Torture, and Black Grassroots Responses to Judicial Inequality in 1920s Baltimore. So you know you're going to hear a lot tonight, and that's wonderful. He teaches in the American Studies program at UNBC, and he's on the faculty for the Public Humanities program there as well. His talk tonight reflects his interest in the relationships between policing, labor, and race. Also, I note that he's involved in grassroots housing justice efforts in Baltimore, working for the past several years with the Charm City Land Trust, which is a land trust in East Baltimore. All right. And he has a book coming out in the fall, so I want to bring this to your attention. The book is called Let Us Alone, The Origins of Baltimore's Police State. And he looks at the relationship between policing, municipal governance, and race in post-Civil War Baltimore. It will be published by the University in October. And as you're excited at the end of this evening's talk, if you want to pre-order it, I'm sure you can do that. Otherwise, just look for it when it comes out in October. I think you'll find it quite interesting. A quick comment about procedures, and then we'll get on to the interesting talk. Michael will talk for 40 to 45 minutes. After that, we'll have question and answer until 8:45. Those on Zoom can hear the questions. The questions will simply come from the people here, and then everyone will hear the answers as well, and responses as well. We'll finish at 8:45, and then we'll be out of the building by 9. So, Michael Casiano, please.
It's too long. I do apologize. Thank you, everybody. Good evening. I'm Mike Casiano. As Howie, Professor Baum, Howie was one of my instructors at the University of Maryland College Park when I was finishing my PhD there. So this is a great full circle moment for me. Thanks to all of the organizers for the event, the Baltimore City Historical Society, and for having me to share this work that I've been working on for a really long time. So today I'm going to be talking about a story that revolves around somebody you probably never heard of. And it forms the 5th chapter of my book, which broadly analyzes the sort of progressive racialization of policing in Baltimore after the Civil War. It traces that from about 1865 to the onset of the Great Depression, where sort of modern policing really took root in American cities. This vignette, this story, which is complicated, admittedly, in which I won't scratch the surface of, broadly emblematizes the way that police torture, and specifically violence, sedimented in this very subterranean way that became the sort of raison d'etre of a lot of policing interrogation methods. So without further ado, I will get into this narrative. So on the evening of January 14th, 1921, Kenneth W. Riley left the Naval Academy grounds and headed to downtown Annapolis. Downtown, he briefly chatted with a friend before catching a movie. Afterward, he had a soda fountain for a sundae. Around 10 p.m., Riley returned to the Naval Academy. On his way back to his quarters, he heard a groan, then another groan. Riley followed the noises and saw an umbrella, a muff, and a white glove strewn on the ground. Frightened, he slowly approached the groans. He discovered a body. The woman, Harriet Cavanaugh, a nurse at the Naval Academy, lay semi-conscious. Blood and vomit caked her clothing and hair. "Oh Lord," she moaned. Riley rushed to get help. He and a colleague brought Cavanaugh to the hospital on a stretcher. Surgeons assessed the nurse and found that she had suffered a depressed skull fracture and other head wounds. She had been hit with a blunt object several times. The surgeons attempted surgery, but she had hemorrhaged too much blood. She died the next day. 3 days later, Harriet Cavanaugh was put to rest at the Naval Cemetery. A military escort accompanied her casket. Her colleagues and friends came out in droves to commemorate her life. Authorities had no clue who killed her. A Naval Board of Inquiry began an investigation but possessed few leads. The same day that Cavanaugh was put to rest, the Baltimore police arrested Henry Alfred Brown, a 19-year-old black naval mess attendant from Texas. The police booked him on charges of desertion, a routine offense. The commander and master at arms of the USS Cumberland, a naval training ship for black mess attendants, traveled to Baltimore to retrieve Brown and take him back to Annapolis. Shortly after his arrival, the Board of Inquiry questioned Brown regarding his whereabouts on the night of Harriet Cavanaugh's murder. He told the board he had briefly been in Annapolis that day to retrieve some personal items, but returned to Baltimore shortly thereafter. Regarding the Washington, D.C.-based Evening Star noted, quote, "It is understood that there is nothing more against Brown at this time than the fact that he is a deserter and that he had been a patient at the hospital at one time," end quote. As the facts of the case unfolded in subsequent months, Brown's culpability never convincingly moved beyond the circumstantial connection per all of the news coverage and the Attorney General's investigation. However, after several days in police custody, a rattled Brown confessed to the murder. He alleged to have done so after experiencing the 3rd degree, a shorthand for police torture at the hands of the Baltimore police. Henry Brown's experience with 3rd-degree torture illuminated the subterranean and progressively private operation of policing in the 1920s U.S. city. Police exercised their monopoly over force to bend due process in the name of law and order. While police power vested state agents and governing bodies with the ability to determine what constituted a legitimate use of force, this legitimacy need not and often did not correspond to what we might consider a legal use of force. In the early 20th century, police relied on discretionary statutes and took cover behind institutional protection to violate due process on the streets and in station houses where they routinely beat confessions out of suspects. National increases in arrests for violent crimes during the 1920s led to a more systematized use of the practice as public sought justice no matter the cost. And this is, all of my captions are not visible. So this is murder and manslaughter arrests represented in per capita rates between 1902 and 1929. As you'll see, before this, murder and manslaughter arrest rates are pretty stable. They skyrocket in the 1920s. This is a national trend. It's not peculiar to Baltimore. And this is the result of several factors, prohibition, etc. We can talk about it more, but it is raising in alarming rates. And police are not equipped to deal with it. And we'll see the conviction rates for a lot of these murders in a second. So guilt and innocence during this period became secondary concerns if someone paid the price. During the 1920s, black men increasingly became scapegoats in cold cases. They endured third-degree torture as calls for law and order, coupled with broader agendas to maintain racial hierarchy in diverse areas of social life, coalesced in black people's experiences of disproportionate arrest, incarceration, and institutional violence. And I won't spend too much time on this, but this is, the police started collecting arrest data based on race in 1895. There are specific reasons for that we can get into in the Q&A. And between 1895 and 1929, which is around the time my analysis ends, there's no point at which the white arrest rate eclipses the black arrest rate. Black arrests are driving the arrest rate in Baltimore City. The real inflection point is the 1920s when, even on a non-per capita basis, black people are being arrested at higher rates in just whole absolute numbers in the 1920s as police are waging this sort of war. And I don't use that terminology in an alarmist way. The police chief at the time is a former brigadier general who fashions the Baltimore police into a set of platoons, and his governing ideology was rooted in his National Guard service and his experience in occupying populations. So the public secret of police violence troubles prevailing in foundational treatments of the rising modern carceral state, while extant scholarship points toward the emergence of a carceral system based on the removal of the individual from society, the presumption that public torture's disappearance accompanied the systemic shift is overstated. As Henry Brown's case demonstrates, black people were vigilantly attuned to police torture, which they understood as central to policing. What is more, violence is not the exclusive provenance of the police, that is, officers wearing badges. It materializes and is legitimized at multiple sites, including the military, the station house, and the courtroom. All three of these sites, particularly the latter, are crucial to Henry Brown's case. As such, this talk, while keying in on one instance of police brutality, draws parallels between Brown's experiences and the broader consolidation of Baltimore's nascent police apparatus. From the conduct of police officials, to the contested nature of truth, to the flagrant violations of due process, to black grassroots responses to state-sponsored violence and injustice, Henry Brown's case offers a glimpse into the evolving nature of Baltimore's police state during the 1920s, when brutalization became a fact of life for black city residents. The contemporary resonance of this case ring clearly and poignantly well into the 21st century. Before I dive fully into Brown's story, I would be remiss not to recognize that today we're gathered on the 160th anniversary of Juneteenth, the day that General Gordon Granger arrived in Galveston, Texas to deliver General Order Number 3, which read in part, "The people are informed that in accordance with the proclamation from the Executive of the United States, all slaves are free. This involves absolute equality of personal rights and rights of property between former masters and slaves." While the Civil War formally ended when Robert E. Lee surrendered to Ulysses S. Grant in April, hostilities continued in Texas, where Henry Brown was from. News of the Confederacy's surrender led to mass desertions and the surrender of General Kirby Smith, commander of the Confederate Army of the Trans-Mississippi, on June 2nd. Following the formal surrender, extra-legal violence, including rioting and looting, occurred as expressions of the lost cause emerged almost immediately in the Lone Star State. While General Order Number 3 proclaimed the freedom of the enslaved, it also offered a glimpse into the obstinance of plantation politics in the South. Freedmen were, quote, advised to remain at their present homes and work for wages, end quote. This corollary dovetailed with enslavers' broader design. Annette Gordon-Reed, in her study on Juneteenth, notes that many Texas slave owners continued to hold black people in bondage well after Juneteenth. At the same time, black Texans took full advantage of their freedom by reuniting with lost family members, enrolling in schools created by the Freedmen's Bureau, and formalizing once illegal marriages. As such, the legacy of Juneteenth is both celebratory in its memorialization of emancipation, while simultaneously reflective of the undue burden of the fights for freedom that black Americans have engaged in to continuously assert personhood in all of its valences. Henry Brown, a Texan deeply shaped by this legacy, endured as best he could when faced by the behemoth of New South-style criminal justice. On a day in which freedom is at the center of consideration, his experiences and those of his advocates will remind us that, as Angela Davis famously noted, freedom is a constant struggle. Thank you. That's my daughter. She was like, make sure to include the Angela Davis one. So in this case, the struggle is one against a criminal legal system that since the end of the Civil War had steadily oriented around the subdual of black freedom. This dynamic was encapsulated in its most violent and virulent form in the practice of the third degree. So at the turn of the 20th century, the third degree became a central element of police work that built upon cops' desires to exert control over suspected criminals and to tip the outcomes of criminal trials toward conviction. Confessions became an effective way to push a conviction through, though suspects were not easily swayed to condemn themselves and were in fact constitutionally protected against doing so. As such, police bent due process and violated other protections as they employed clandestine torture to extract confessions. This is a political cartoon that was published in the Afro during the broad-scale campaign of the Citizens Committee that was formed to redress and exonerate Henry Brown. And so we're very attuned to this, and we'll get into a little bit more of that response in a second. In the early 1900s, tales of third-degree torture began to pepper daily newspapers as the practice became a national curiosity. For instance, the National Theater in Washington, D.C. mounted a play based on Charles Klein's novel, The Third Degree, for a week in 1909. In it, a young man awakened after a night of binge drinking to find a dead man in his apartment. In a review, the Washington Post noted, quote, Klein shows that a man in a semi-dazed condition may be made to submit to a stronger mind than his own, and through this hypnotic influence admit a knowledge of things to which previously he had no knowledge, end quote. Such hypnotic suggestion shrouded the practice in mystery while raising questions as to its legality. Residents of the nation's capital described the national rash of third-degree incidents as the American Inquisition and a threat to the essence of democracy itself. As news stories, cultural production, and victims' complaints animated the popular imagination with portrayals of concealed, mysterious, and illegal interrogation methods, police defended third degree as nothing more than good police work. Police argued that sophisticated examination techniques would lead to higher conviction rates in instances of murder and other violent crime. Despite victims' detailed stories of harsh physical torture, police rarely admitted to the brutalization of suspects and did not consider prolonged and arduous grilling sessions wherein people were kept awake for hours and hours and hours on end until finally they just gave up and said, I did it. The emergence of widespread third-degree abuses coincided with rising violent crime rates, as we talked about, but also public exhortations to ameliorate this violence, particularly murder. And this was the case because police were not great at solving murders. So this is a 7-year sample of murder arrests. So these are the people who are arrested for murder between 1917 and 1923. So between this period, the Baltimore Criminal Court presided over 223 murder cases. Of these, Black Baltimoreans served as defendants before all-white juries 118 times, so more than half the time. Over the course of the 7-year sample, Black defendants were convicted 67% of the time, while white defendants were convicted 49% of the time. And you can see this visualized here. Yet and still, take, for example, 1923. In 1923, there were 23 convictions. There were 100 arrests. So police were not getting people into prisons, they were not getting people into jail. Over the course of the decade, that would change a little bit, but this broader history does sort of play into what a lot of abolitionist organizers argue, which is that police are not effective at the job that they are purported to be doing in the first place. They do not lessen crime, they do not solve crime, and that has been the case for at least, to my estimation, 125 years. So the police seem, based on the amount of arrests that were being made, at least publicly, had become better at detecting crime, which was a reasonable assumption, sort of given the large public demonstration of, or public sort of reputational valence that they possessed. But equally reasonable were suspicions, and quite more than suspicions, that the Baltimore police, like police departments around the country, violated due process to compel confessions, and that is what 2 Baltimore police detectives did in 1921. So Henry Brown's culpability in the murder of Harry Cavanaugh, hinged on a confession. Confessions had murky legal foundations, but nonetheless represented the spirit of socialized justice that typified American jurisprudence at the turn of the century. The administration of justice in the early 20th century embraced socially responsive forms of legal execution that engaged the pressing social and political problems of crime. Tough law and order values stemmed from social agendas that valorized orderly societies, moral uprightness, and the management of hereditarily unfit people. Progressive reformers propelled this brand of social justice, a different kind than what we talk about. As courts reviewed more cases and punished suspects at a greater clip in the first 3 decades of the 20th century, some of the social values that drove courts and progressive court reformers stemmed from latent and blatant eugenic ideals. As such, courts became sites in which prevailing social antagonisms, including and especially racial ones, animated the legal administration of crime. In the case of Henry Brown and countless other third-degree victims, this dynamic manifested in the court's acceptance of the coerced confession. Ignoring the unconstitutional methods by which such confessions were secured, courts also tended to overlook the dubious legality of the confession itself, a form of self-incrimination that, when coerced, was almost certainly unconstitutional. The technical and legal foundations of courts in many cases became secondary to the efficient and socially responsible forms of judicial disposition, especially in Brown's case, which involved the murder of a white woman. Given this reality, the Baltimore police ruled out all the stops by assigning some of the worst police officers, Peter Bradley and Henry Hammersley. So Peter Bradley served the Baltimore police for 33 years. He became a detective in 1903 and developed a reputed expertise in criminal classification. Given his reliability, Police Commissioner Charles Gaither ordered Detective Bradley to Annapolis on Tuesday, January 18, 1921. Gaither instructed Bradley to choose a partner to aid the investigation into Henry Brown. Bradley selected Harry Hammersley to accompany him. Hammersley had a checkered past. Scandal characterized his career. For instance, he was once caught obstructing investigations into saloons to which he provided protection. He was once dismissed on multiple counts of insubordination from the police department. He was once implicated in the rough treatment of a suspect during a protracted interrogation. He was once caught extorting money from a wealthy broker. He was several times caught violating departmental rules. You get the picture? Bad guy, bad employee. Together, Bradley and Hammersley provided expertise, or perhaps more accurately, possessed the unrestrained gall to solicit the confession. Both had familiarity with sweating and likely had experience with far harsher interrogation strategies unrecorded in the police's archives. So Baltimore's finest arrived in Annapolis and requested a closed-door meeting with Brown. After just one conversation, the Baltimore police detectives managed to do what the Naval Board of Inquiry, the Bureau of Justice, the Department of Justice could not do. Henry Brown signed a confession for them on the spot. According to Brown's signed confession, he had traveled to Annapolis on January 14th to turn himself in for desertion. Upon arrival, Brown met another black seaman who dissuaded him from surrendering. Convinced, Brown supposedly went off to find someone to rob. When he could not find anyone, he decided to surrender after all and resumed his path back to the Naval Academy. He encountered Harriet Cavanaugh there. Seeing an opportunity to finally commit the robbery he had abandoned and, in fact, had had no intention to commit in the first place, Brown grabbed a piece of loose iron pipe and hid behind a tree. Thoroughly hidden, Brown emerged and struck the nurse on the head once with the pipe, fracturing her skull in 3 places. He then grabbed her pocketbook, kept the $8 inside, and tossed the evidence. He headed downtown, spent all the money, and traveled to Baltimore that same Saturday night. If this confession sounds far-fetched, overcomplicated, and convenient, it is. Brown's seemingly incoherent actions, including his immediate susceptibility to the suggestion that he robbed someone, instead of surrendering for desertion, echoed racist presumptions that prevailed during the period regarding black men's supposed uncontrollable susceptibility to crime. It did not read like the actions of a black teenager, Henry Brown was 19, on the lam for desertion. Instead, it read like a document clumsily put together by white racists that would activate an all-white jury's prejudices against black criminals, while also corroborating the rest of the unaccounted for physical evidence in the case. In the confession, Brown's exact knowledge of the murder weapon and where Cavanaugh's pocketbook had been thrown made the prosecution's job a piece of cake. The fact that nobody saw Brown in the act also made the prosecution's case simpler because they did not need to locate eyewitnesses. According to Detectives Bradley and Hammersley, these gentlemen, extracting a confession was simple. They deployed religious talk. They also benefited from Brown's delirium. He had been kept awake for several days. When the commander of the Cumberland brought Brown to the detectives, he trembled from anxiety and sleep deprivation. This was something that was fully admitted to during his trial. Brown feared a potential lynch mob, Annapolis, and reportedly told the detectives, quote, "Gentlemen, if you'll take me to the Baltimore jail instead of to Annapolis, I will tell you the truth." End quote. Brown reportedly confessed in exchange for the detectives' word that they would prevent his lynching, a foreboding omen. After securing the confession, DOJ agents transported Brown under cover of darkness to Baltimore. Since the murder occurred on federal property, the U.S. District Court presided over the case. On February 2nd, Brown appeared before a U.S. commissioner and used the opportunity to recant his confession. He alleged that he had not been in Annapolis when the murder took place. He had been in Baltimore and he had witnesses. He further alleged that he had only confessed after days of torture. According to Brown, while confined in the brig of the Cumberland, he had been kept forcibly awake, had a rope tied around his neck, had been threatened with lynching, had been jabbed in the ribs with a bayonet, had been shackled around the wrists, and had been beaten across the back. Additionally, when the Baltimore detectives arrived, they menaced him with a blackjack and, knowing of his anxieties of being lynched, had threatened to turn him over to the ship's crew to be hanged. Brown's story did not sway the grand jury, which charged him with first-degree murder. Brown's retraction caused a firestorm in the press. The detectives denied his accusations. Simultaneously, charges that Brown had been subject to the third degree began to crop up in newspapers. The authorities involved in Brown's torture seemed uninterested in hiding what they did to him. According to a Washington Times article, DOJ agents fully admitted that Brown had been brutalized and that he was on the verge of a nervous breakdown, quote, when turned over to the Baltimore detectives. Despite ongoing investigations into other suspects, the U.S. District Court rushed Brown's case to trial. The pressing social and political implications of a white woman's murder in a southern state, for the sake of argument, whose political apparatus and citizenry demanded racial retribution, influenced law enforcement to pursue prosecution despite suspicions on other suspects. Brown faced the brunt not just of the legal system, but of the social and ideological orientation of a policing apparatus that sought justice no matter the deficiencies in its investigations. For Henry Brown and countless like him, justice was not blind, but fully perceptive and quick to judgment. The Sun anticipated, quote, a quick trial of Brown if no unexpected obstacle develops. Brown's fate seemed sealed from the start. His trial began on March 28, 1921. John C. Rose, an esteemed judge and noted social reformer in Baltimore, presided over the case. Rose had earned a stellar record as a public servant in the late 19th century. He served as secretary for Baltimore's chapter of the Society for the Suppression of Vice. He also presided over a 1917 case that deemed residential segregation unconstitutional. After his death in 1927, Warner T. McGuinn, a decorated lawyer who argued that case before Rose, wrote a sterling obituary in the Baltimore Afro-American for the late judge. He noted that, quote, "In his court, all men stood equal before the law," end quote. Brown could not have been assigned a better judge. U.S. attorneys, Helm prosecution, August W. Schnepp, a real estate lawyer, defended Brown. The whole case came down to the confession. Would Rose toss it, or would he leave it up to the jury? The trial took place over the course of one day. During the trial, inconsistent testimony regarding Brown's whereabouts, as well as testimony from the ship's crew that Brown had in fact been beaten and kept forcibly awake, made the admissibility of Brown's confession the only path by which to convict him. Rose, notably in the jury instructions, said to disregard the eyewitness testimony of who was going in and out of the Naval Academy because there were too many instances in which the inconsistent testimony made it impossible to trust any of the witnesses. Rose deliberated on the question of admitting the confession thoughtfully. Perhaps given his long, intense history with the Baltimore police, Rose tossed that confession and made it fully inadmissible. However, and perplexingly, Rose allowed the jury to take Brown's confession before the Naval Board of Inquiry into consideration. Brown had confessed twice. He threw out one confession. They were identical. This tool was all the jury needed. After 22 minutes of deliberation, the all-white jury found Brown guilty of first-degree murder. Rose denied Brown's motion for appeal. He condemned Brown to death by hanging on June 2nd at the city jail. Henry Brown's quick case demonstrated broader dynamics in racialized criminalized justice and the function of courts. Regarding the former black people's exclusion from juries created a racial imbalance that vested condemnatory legal power in white citizenries. The Afro, in examining, I believe, this case, took umbrage with this convention and noted that in cases where black men and women were excluded from jury service, quote, "practically the man is tried by a jury of superiors," end quote. Given the racial reckoning that Brown's case would spark, this type of conventional and systematized racism proved far larger than one young man's case. It spoke to deeply entrenched forms of white supremacist social organization that denied black people the rights and privileges associated with civil life. Moreover, the court's decision to uphold the signed confession, despite clear admissions from Cumberland crew that Brown had been kept awake and beaten, as well as conflicting testimony regarding his whereabouts, spoke to the court's compulsion to convict as a social responsibility rather than an impersonal and objective administration of justice, if such a thing exists in the first place. The rushed trial, the abandoned inquiries into other credible suspects, and the retention of the compelled confession represented the court's desire to convict in the interest of the white polity. However, Baltimore's black political class would not accept the decision so easily. In their examinations of the case, they found the court's decision rushed and lacking proper investigation. They conducted their own investigation, and though Rose condemned Brown to hang on June 2nd, he did not. Spearheaded by Laura Wheatley, a fractured, though effective collective emerged to fight for the young man's life while navigating the complexities of black politics in Baltimore and Maryland. Laura Wheatley, an Afro-Southern transplant and descendant of enslaved Kentuckians, came to Baltimore by way of Louisville and St. Louis in 1906. Armed with the lessons she learned living in radically different areas of the country, Wheatley became disruptive in Baltimore's black activist circles, particularly the local branch of the NAACP, where she rose to the ranks by helping the fledgling branch recruit its early membership base. Wheatley's resolute commitment to the Baltimore branch, coupled with her determined efforts to mold the branch's activities around redressing the injustices experienced by Afro-Southern migrants and everyday Baltimoreans, ruffled feathers. She bumped heads with branch leadership, which consistently refused to allocate time and resources to her many crusades. The Baltimore branch struggled to keep its head above water and could not fulfill its operational duties, let alone pursue the types of campaigns that Wheatley considered its central duty. She remained undeterred. She continued pursuing justice for the unjustly treated. It was hardly surprising then that a meeting with Henry Brown, the young Texan on death row for a crime he may not have committed, galvanized her to organize a citizens committee to fight on his behalf. When Wheatley joined the fight, she immediately reached out to the Baltimore branch of the NAACP to galvanize the membership that she had recruited around Brown's cause. They again refused her crusade. The campaign would be hard, and she would need to find help elsewhere. To that end, Wheatley joined Emma Truxton, a social worker, and Boston Allen, a reverend who was the one who secured Brown legal representation, in the fight for the young man's exoneration. Allen had taken notice of the case first and introduced it to Truxton, who reached out to her representative to secure a meeting with President Harding, who shockingly agreed to it. At the meeting, the Citizens Committee went over the case with a fine-tooth comb. While the prosecution could not produce a single witness to definitively place Brown at the scene of the crime, the committee found several Baltimore residents who had seen him when the murder took place. The witnesses in question were hesitant to testify. Brown had evidently been at a brothel when the murder took place. The brothel proprietor refused to corroborate his story for fear of self-incrimination. The Citizens Committee wrapped up its presentation and headed back to Baltimore. In the following days, they sent affidavit upon letter from residents and witnesses who corroborated Brown's alibi and implicated the police in using intimidation to steer witnesses away from testifying on his behalf. According to J. Stewart Davis, Brown's new attorney and general counsel to the Citizens Committee, the police routinely intimidated black witnesses to either compel or discourage them from testifying. In a letter to Attorney General Harry Doherty, Davis recounted an instance in which police arrested a man who refused to testify on their behalf in a case. They booked him on a vagrancy charge and had him incarcerated in the House of Correction. Two other witnesses who signed sworn affidavits alleged the same had happened in Brown's case. They were privy to the fact that Northwestern District Police had threatened potential witnesses with incarceration if they corroborated Brown's alibi. Given the sheer magnitude of the Citizens Committee's labors and the evidence brought forth, which potentially corroborated his alibi and someone in great doubt regarding the criminal legal system in Baltimore in general, the Attorney General simply could not ignore the shakiness of the case. 2 days before Brown's scheduled execution, the condemned man received a surprising respite. President Harding granted Brown a 30-day stay of execution. The Office of the Pardon Attorney, seemingly convinced by the Citizens Committee's evidence, filed a formal petition to Harding and took up the case. An initial assessment revealed that Brown had not been properly informed of his rights. The Attorney General's office also found discrepancies in the testimonies of the prosecution's witnesses. After further investigation, the Attorney General recommended another stay of execution, which President Harding granted. This time, Brown's life had been spared until August 1st. So, eluding death not once but twice, Brown's case transformed from an open and shut case to a matter of intense public scrutiny. And now people wanted blood. Some of Maryland's white population and loudest newspapers, exhortations for Brown's hanging demonstrated both a desire for mob-style justice that preserved the racial status quo and more importantly, an intense fear of the effectiveness of black collective power. White newspapers, particularly the Sun, ran countless stories and scathing editorials on the developments of Brown's case, as well as several other exposés that highlighted black crime in other parts of the city and state with biting editorial flourishes. For the Citizens Committee and their supporters, Brown's case represented a grave injustice that revealed police corruption and brutality, the inherent racism of the judicial system, and a disregard for due process that disproportionately affected black Baltimoreans. For many white citizens and news outlets, the case represented nothing more than a black man's attempt to get out of paying the price for a crime to which he had already confessed. Beyond Brown's case, the public discourse surrounding his potential exoneration revealed the degree to which blackness had become sutured to violent crime and white racist imaginaries. Brown's circumstances revealed a long array of racialized discourses that led to the consolidation of Baltimore's increasingly anti-black criminal legal system at the turn of the century. The bloodthirstiness with which onlookers conducted themselves, including the governor at the time, Albert Ritchie, new governor, would-be governor for 15 years, who openly called for Brown to hang, spoke to racialized execution trends in Baltimore. Between 1844 and 1873, no black people were executed in Baltimore City. Black rates of execution spiked and followed increases in rates of arrest and incarceration after the Civil War, when free black people became a supposed problem that only brutal repression could fix. From 1873 to 1923, 13 people were executed in Baltimore City Jail. 11, or 85% of them, were black. Black men were hanged on charges of murder, rape, and assault, which followed a national trend. In addition to executions, in cases where suspects were not sentenced to death, they often still experienced corporal punishment in the form of lashes. As such, in Henry Brown's case, much of Baltimore and Maryland's white public was animated by complementary compulsions to protect white women's safety and enact routinized and brutal violence. Whether through lashes or the noose, in one telling editorial, in the Evening Sun, the editors used, quote, "Lynchings have gone out of fashion in Maryland, in spite of many horrible crimes in recent years. It would be a terrible pity if a mistaken sympathy for a black murderer should revive the practice," end quote. By the paper's implication, Brown had been right to worry about a lynch mob while trapped in the brig of the Cumberland, though wrong to seek refuge in Baltimore. While some white press coverage condemned Brown, the U.S. Office of the Pardon Attorney wrapped up its investigation into the case. On August 18, 1921, 3 weeks before Brown's scheduled execution, James Finch forwarded his recommendation to the Attorney General's office. Throughout the process, Finch and his office had gained the trust and adulation of the Citizens Committee. Indeed, in a letter to Finch, Laura Wheatley raved, quote, "Our committee has the confidence to trust this case with God and you," end quote. The feeling was mutual. Finch, in his report, described Wheatley as very intelligent, educated, and refined, and said, in whose judgment and veracity I have entire confidence. Finch's extensive report examined elements of the trial and subsequent investigations to square away puzzling details in an error-laden case full of contradictory and doubtful testimony and evidence. In examining the evidence gathered by the military, the government, the Baltimore police, and the Citizens Committee, Finch took issue with the Board of Inquiry the Naval Committee put together initially to investigate the case. Just to say very quickly, his report focused on the fact that there were two people who had very credible suspicions on them who could have likely been there when Kavanaugh died, which is not to say that this could have exonerated Brown, but it just sort of went away after the conviction came through. So while Finch did not assess any of the evidence enough to exonerate Brown, he did find the material evidence and witness testimony compelling enough to conclude that they, quote, "should be investigated further before Brown is permitted to hang." For months, the Citizens Committee worked with Finch by collecting evidence, submitting affidavits, and ensuring that his office had access to all the information it needed to make an informed decision. Their legwork paid off. Finch concluded that, quote, "there is a very real possibility, but a possibility that a mistake might be made," end quote. As such, Finch recommended a commutation for Brown. Instead of death by hanging, the young man should face life imprisonment. Finch forwarded his recommendation directly to the Attorney General, and that is where his work, the Citizens Committee's work, and Brown's life was ultimately ignored and invalidated. Dougherty reviewed Finch's report, considered his recommendation, and made his own. Like Finch's, Dougherty's report seemed to suggest that Brown's guilt was doubtful. He noted that Brown had been, quote, "convicted wholly upon circumstantial evidence," end quote. Regarding the confession, the Attorney General noted, quote, "there is not the slightest reason for suspecting him of the crime except his own admission, which was certainly induced," end quote. Dougherty conceded that Brown's treatment was reprehensible and torturous, but that ultimately Brown could have just told the truth anyway. Given this callous assessment, Dougherty ignored Finch's recommendation and advised President Harding to deny Brown's petition for executive clemency. The president obliged, and Brown was sentenced to hang on September 1st. A U.S. Marshal delivered the news to Brown at the city jail. He reportedly received the final decision stoically. Shortly afterward, Brown called on Laura Wheatley. She went and spoke to him one final time. She noticed that he was distant. It took him long to respond to her questions. When he did, the answer seemed rushed and off topic. She noted, quote, "He answers for politeness before he realized what was said to him," end quote. Before I conclude, I want to say something about this photo. So this photo represents Henry Brown's clothing accurately. He was wearing his naval officer suit throughout this entire ordeal for months and months and months. What's, I think, broadly symbolic about this image is that in the NAACP files where it's kept, it's stapled to a piece of paper that Laura Wheatley wrote. She with her chicken scratch wrote, "This picture looks nothing like him." And I think that's broadly representative of how, during this entire process, he's not known, seen, or represented. And that we still don't know what he looks like, and probably never will. To conclude, on August 28, 1921, Henry Alfred Brown, in his last-ditch effort to escape the gallows, penned a letter to President Harding. It is one of the few pieces of archival material to catalog Brown's voice. It reads, "Dear Mr. President, I am to be hanged on Thursday, September 1st. Mr. President, spare my life and commute my sentence. I am innocent of the crimes charged against me. In the name of the good Lord, ask his mercy for me, a poor colored boy. Dear Mr. President, I ask mercy at your hands. May God bless you and your family. Henry A. Brown." The president ignored Brown's letter, and on September 1st, 1921, guards escorted him to the bake shop of the city jail where the gallows had been erected. Standing atop the scaffold, the teenager uttered his final words. Quote, "I thank the public, both black and white, for all they have done for me. I know how I got into this trouble, and the man who got me in knows. Someday, you all will know. I'm going to meet my God. I'm not afraid to die. I know God will take care of me, and I want you all to pray for me." The executors sprung the trap at 7:49 a.m. Brown died shortly thereafter. While it is impossible to know who killed Harriet Kavanaugh, over the course of Brown's arrest, interrogation, trial, condemnation, reprieve, and execution, revelations regarding the case provided substantial and reasonable doubt concerning his guilt. Brown served as an early use case that demonstrated the effectiveness of third-degree torture at the beginning of a decade where it would reach untold heights. The tactic would only become more commonplace in subsequent decades as public spectacles of cruelty and murder perpetrated against black people became increasingly private and staged in secluded police station houses. Though the Attorney General and his office expressed significant misgivings about Brown's trial and admitted that he had been tortured, the collective will of the state's white political establishment appealed to the safety of white women to rush Brown's execution. Though just one case, Brown's experiences in the courtroom and as the subject of public debate regarding the nature of blackness and racial politics illuminated several key facets of Baltimore's burgeoning police state. First, the story of policing in Baltimore had been one of increased discretion for police officials, including cops, judges, and politicians. As police battled for cops to have greater access to the bodies of individuals, national trends in policing sought even greater protection for cops and detectives who deployed violence to compel suspects to confess to crimes. The third degree stretched the so-called reasonableness of police power to a senior breaking point, though courts, in accepting confessions secured through violence, validated its use and tacitly endorsed the practice. This compulsion melded with broader judicial trends in which courts became sites of social justice rooted in progressive ideals around the ruinous effects of crime. What it also illuminated was the state of black politics in Baltimore, especially in reference to policing and judicial reform. While women like Laura Wheatley fought tooth and nail alongside her supporters to exonerate Brown, these supporters were few and far between. Black organizations like the NAACP contained multitudes as black organizers negotiated pragmatism, respectability, radicalism, and all manner of approaches to pressing racial issues. While Wheatley embraced a more radical orientation, her dismissal of pragmatism revealed how white supremacy manifested in repudiations of effective black mobilization, that challenged police power's capacious affordances. Brown's case foreshadowed what Black Baltimoreans' experiences during the 1920s would be as police power expanded its jurisdiction, discretion, and brutality to historically unseen heights in the city. The movement surrounding him also emblematized, in the spirit of today, that freedom is a constant struggle, and that Black Baltimoreans then and now struggled constantly and righteously. Thank you.
Now we have time for questions and answers. Well, there will be answers for questions if there are questions. So. Please.
I have a few comments. First, I really enjoyed your discussion. Secondly, I can't help to think of the relationship between eugenics, chronology, and racism. Because to me, there are three things in one, particularly when it comes to the chronology, where Black people were treated with a criminal justice system that was not designed for them. Secondly, to juxtapose what was happening in America, roughly 100 years earlier, England experienced Pelian reform. And over that period of time, say between 20 and 25 years or so, the men not only get guns out of the hands of everyday people, they also created a system of justice that was really very 20th century justice. And I find that very interesting that England could do that, but America was mired where we were, and in some ways we were still there. Because we're still where we were back at the turn of the century.
There were two kinds of comments. One had to do with relations between eugenics, phrenology, and racism in the story here, and another had to do with contrast between British reforms, which took place earlier than in the United States, and what might explain the cultural differences between the two countries. Do you want to respond to either of those?
Sure. Yeah, the role of phrenology and eugenics and the sort of like shift from thinking about deficit biologically to thinking about it sort of culturally, and the sort of cultural explanations for Black crime typified and justified a lot of discretionary policing. There was a sort of idea that, and it's propagated not, it was a very sort of like common idea. Like William Cable Bruce, who was a senator from Maryland, penned sort of a screed that said there is just an inherent incompatibility between formerly enslaved people and civilization. And as such, there needs to be some kind of excommunication from politics, the removal of suffrage, and the institutionalization of a kind of policing apparatus that would subtend an inherent inferiority. And all of that was fueled by this kind of like racist science. So that's the first question. To the second question, I don't know why. I mean, it's the sort of constitutional question, the Second Amendment, but that was at the root of why there was so much violent crime in the 1920s. Frankly, guns got better and got more lethal, and Americans started turning them on each other, organized gangs or prohibition and things like that. And so that also sort of contributed to the spike in violent crime, murder, manslaughter, and things like that. And also cars. People were running on cars when they were first introduced and sort of popularized. So, yeah, thank you. Yeah.
So, you mentioned, as you were starting in the topic, you mentioned that the public started having a serious fascination with the idea of third-degree confessions and torture and things of that nature. Do you find that the plays and the stories that were being told, were they pro-torture or were they critiques of the police? Because we know, of course, entertainment is about, bolstering the lawmen and all that jazz. So what did you find in the 1920s? What was the art movie?
Yeah.
Paraphrase it?
Yeah.
Rephrase the question.
Yeah, I'll rephrase the question. So, the question is, how was third degree represented broadly culturally in media, whether it was sort of pro-torture or anti-torture. The question is, or the answer is both, but and that's the cop-out answer. The real answer I'll give you is that there was and continues to be this fascination with the genius detective. And what the third degree sort of represented was the ability of a human being through moral suasion to extract the truth from an unwilling participant in the interaction. And that was certainly sort of the Charles Klein version of this. And I mean, we continue to see, I mean, how many times will they reboot Sherlock Holmes and pretend like police solve crime? It's just numerically and empirically false, right? And so that was sort of the public fascination. But I will also say that in the 1920s, the Baltimore police was a gang on the streets, and people in newspapers as mainstream as the Sun were saying, like, this has gone too far. There was a period, and I can't remember exactly, it's in the 6th chapter of my book where I talk about, there was like a 2-month period where 6 people were like murdered by the Baltimore police. And it was a sort of like flashpoint moment. One of them was a man named Charles Williams, who was murdered in his own house. Police officer off duty knocked on his door. He closed the door in the dude's face. The dude blew a hole through the door and then went inside and killed him. And unanimously, it was like, the police are out of control. And it is not coincidental that in 1929, the federal government will publish the Wickersham Commission's reports, which say that this is an endemic problem in policing in the United States. And it's called Lawlessness in Law Enforcement, the specific one of those reports that talks about third degree in particular, and noting that it was not an aberrant form of interrogation, but it was the premier de jure form of interrogation. So that is the sort of long answer to your question. Yeah. Yeah.
2 questions. Number 1, why is torture called the third degree? And then number 2, why do you need 2 confessions for the same crime, and why did the judge ever explain why he didn't make one not the other in any public documents or anything like that?
Yeah. So the first question was, why is it called the third degree? The second is, why do you need 2 confessions for the same crime?
And also, why do you need one and not the other?
Why would you admit one and not the other? So it's called the third degree because it's the third step that the police take after they arrest somebody. So the first step is the arrest. The second step is detention. And the third step is interrogation. And so it's the third degree of, like, the continuum of a person being taken into custody by the police. So that's the first question. The second question is, why do they need 2 confessions? They needed 2 confessions bureaucratically. So the Board of Inquiry was doing an investigation at the same time that the Baltimore police were doing an investigation. And so the Board of Inquiry received the same confession from Brown that the Baltimore Police Department did. Rose judged the second confession to be less corrupted because he had representation every time he talked to the Board of Inquiry. And so that was his justification for admitting it into evidence. Yeah.
It's a great talk. I was curious to hear a little bit more about the role of the NAACP, and you kind of alluded to internal tensions in the chapter between Laura Wheatley and a larger chapter. I wasn't sure if you meant in regards to the case, but I was kind of curious what the chapter of the national organization had anything to say about the case, because I was just thinking about criminal defense was something that really divided the organization nationally. And it seems like with the Scottsboro Boys case, which is, 12 years after that, or 10 years, NAACP is very slowly involved in that, and part of why they get involved is because communists and national labor defense kind of beat them to the punch. And it seems like NAACP a lot of times is really worried about how crimes of character and, any crime, they're very, very slow to say, this is a black man who we can defend without selling our organization's name. They have to be almost saints.
Yeah.
So I was curious if this dynamic existed at all here, or if there were like internal debates within the local chapter to get involved, and if Wheatley was leading a charge against people who didn't want to get involved, but maybe I'm imagining this.
No. This actually forms a crucial part of that section is the relationship between both the local branch of the NAACP and the national NAACP. So that's broadly the question is what was the role of the national office of the NAACP, and how did sort of broadly respectability play into whether or not they decided to take up this case. So the answer is also complicated. Laura Wheatley was on a mission to save this boy. She was sending letters to James Weldon Johnson as fast as she could write them. It is just, that file at the Library of Congress is just stuffed full of letters to James Weldon Johnson that were not answered. Him not answering, I can only speculate as to why. But as you point out, LaShawn Harris wrote about this with the Virginia Christian case, where the NAACP was like very upfront about like, we're not taking this case on because this will potentially leave us up to scrutiny or criticism, and they were having their own problems with Warren G. Harding, and Tulsa had just happened, and the anti-lynching bill was in the office, and it was passing through Congress, and Haiti was occupied. Like, there were so many things going on that either James Weldon Johnson wouldn't put his neck out for what was be considered sort of inhumanely small potatoes, or he didn't get the letters. So he wrote a letter saying the NAACP is in full support of what you're doing, and we're impressed by the Citizens Committee, that arrived 2 weeks after Henry Brown was hanged. I don't know what to make of that. I've talked to other people, like, what do you make of this? One historian told me he's lying. I don't know. Yeah.
Thank you so much for this wonderful talk. I have two questions. The first one is about his, coming from Texas. And to understand why you made the connection at being Juneteenth, so happy Juneteenth, but I was wondering whether in the case that is made in the media, that mattered. So maybe I'm too stuck in the 1960s where you have all who are about people from outside coming to, disrupt and cause a riot in our cities. But I'm wondering whether that is an issue also in the 1920s, that he is from Texas, for those who advocate for basically his execution. The second question is about surviving relatives. Are there actually any surviving relatives, and have there been any efforts to, posthumously exonerate him, have his case be more widely known? Or maybe that's a teaser for the book.
Yeah. So the first question is, so I mentioned that he was from Texas for a couple of times, and whether or not that played into attitudes towards the case. And the second question is, are there any surviving relatives? I'll take the second one first because it's sort of easier. He was 19, he didn't have any kids. There are so many Browns on Earth that I couldn't locate family, positively. So I don't know, maybe. My hope is that somebody will read this and then maybe we'll reach out. The question about its origin. So there is, Baltimore is a weird city, we all know. There is sort of deep distrust. So part of Laura Wheatley's background is that she is an Afro-Southern transplant. And every time she brings a case specifically about helping somebody from the South get acclimated to Baltimore, the local branch of the NAACP just outwardly rejects her. Like, this is not important to us, this is not something that we do, this is not something that we're interested in doing. All of your crusades, and it truly was so many. There was one case of somebody from Bainbridge, Georgia, who had escaped a lynch mob and had, found his way to Baltimore, and Laura Wheatley coming in contact with him and was like, all right, we'll find you a job, like, there's a great organization here that helps people like you, like, that's their mission. And they were like, get lost, we don't care about this. And so she paid for him for his lodging for a little bit and then his transit so he could go up and meet his relatives in Jersey City. And so there was just a general sort of aversion to the Afro-Southern transplant. And broadly, nationally, that was part of this sort of imaginary, particularly during the Great Migration, that there are so many African Americans moving from the southern United States into the north, and they are bringing these problems. And these problems are affecting both cross-racially and intra-racially. And so I think his origin played a lot in the local branch's sort of dismissal of the case offhand, in addition to all of the other respectability sort of weights that would attend it as well. Yeah.
Yeah, maybe it's my own prejudice here, but I was surprised then that the Harding administration took this so seriously. My view of the Harding administration, wouldn't have thought so.
Yeah. So the question or the comment is surprised that the Harding administration took this seriously. That was also touched on by the Citizens Committee. They were wary of him, and they had every right to be. He was an awful president, just corrupt, and he was very sort of symbolically supportive of. Like, he spoke in support of an anti-lynching bill and stuff like that, but it was all sort of vacuous. And at the end of the day, Laura Wheatley wrote of Harding that she thought, God, I wish I could remember the quote. It was something like, as always, Harding does what Harding does. He tries to appease everybody and ends up appeasing nobody. And that was the sort of attitude they had. They knew that they were sort of pushing a boulder uphill with him, and yeah, it was shocking. But at the end of the day, in the postmortem and in the debrief that of which there's any evidence of, Laura Wheatley was very much of the impression that he was always going to hang Henry Brown.
A light question, but Laura Wheatley sounds fascinating.
Yeah.
Do you have any plans to write a book about her?
The question is, do I have plans to write a book about Laura Wheatley? There's not a lot about her after this. In 1952, she's in LA. She leaves Baltimore. I believe her husband dies. And there's not much else about her. But I don't think you could fill a whole book, but I'm interested in knowing more about her for sure, and more about these sorts of kinds of like local activists that at least I've never heard of or read of. Were integral in a lot. I mean, this case was like massive, had massive national implications, and reached all the way to. I mean, you had Albert Ritchie and Harry Doherty arguing in the local newspaper, just sending letters back and forth. Harry Doherty going like, I mean, this is a miscarriage of justice. I mean, this kid was convicted on circumstantial evidence, and then Albert Ritchie going, to protect the white women of the state, you must hang this man. And the other thing that happened is that Laura Wheatley reached out to a white representative, J. Charles Linthicum, and he wrote a letter in support of her, which called her a very influential member of his district. That description of influence was taken by the white press as a politicization that basically collapsed the Citizens Committee's campaign. The prosecutor of the case came out and said, "What do you mean she's influential?" And that started to sort of ring alarm bells. And in Baltimore City, there were several cases where police accused black people. There's the story of the black dentist who gets stopped by a police officer, and the police officer says, the reason that I brutalized him was because he said he was influential. And so there's this like broad rejection of influence or agency or political efficacy that was used as a sort of way, as a sort of dog whistle, essentially, of saying like, this is the moment in which we have to clamp down no matter what, because this woman's getting too big for the britches, essentially.
Could I ask a question?
Oh, yeah.
I was wondering in this story whether there were white individuals or white organizations in Baltimore that opposed the treatment of Brown or had questions about the use of the third degree.
Yeah. Yeah, so there was a suffragist organization comprised entirely of white women, like the mythologized like victims of this case, who came out and said, "This is asinine." Like this, like we read about this case. This case doesn't seem legitimate. It's in the broader chapter. J. Charles Linthicum. God, I can't remember. I think it was Isaac Loeb Strauss. Somebody wrote to, some like high-profile Baltimorean wrote to Harry Doherty and suggested, or sort of pled for Brown to be exonerated. So there were some allies in the Baltimore American editorials who were much less virulent and were actually sort of like used in the compilings that Laura Wheatley had to send off to folks. She sent it to James Weldon Johnson. She also sent it to James Finch of Baltimore American Stories, being like, if you won't listen to us, listen to the white press that's also saying this. So there was some of that for sure.
Other questions or comments? Got a couple minutes? Please.
Was aggressive interrogation in the third degree, was that also used against white people?
Yeah, so was aggressive interrogation of the third degree used against white people? Yeah, it was. I think it was broadly systemic. I think it was experienced less proportionally because by the 1920s, black people were being arrested at higher, more proportional rates for crimes that would require an interrogation. So yes, absolutely. There are a couple of instances that I know. The protagonist of Charles Klein's novel is white. There were other instances that cropped up in the press, particularly around, I think it was a white bookkeeper in Chicago who was young, who experienced the third degree and hanged himself afterwards. So yes, absolutely. But yes, it was certainly disproportionately used against Baltimoreans specifically.
That leads to, while it's maybe a decade or two later, when Baltimore, the other kind of disfavored population Baltimore got in terms of the police was the white Appalachian migration. And I was wondering whether, there's similar issues with the police in that population.
For sure. That is kind of the subject of my next project. Oh, sorry. The question was on white Appalachian migrants to Baltimore, whether they experienced this kind of treatment from police. And Yes, the answer is yes. Specifically, I'm looking at the relationship between police and labor during the 1920s. Specifically, in 1921, this was one of the sort of like last strikes during that depression of 1920 to 1922, and there are several poor white engineers, stevedores, and longshoremen who have sort of protracted confrontations with police that break out into violence, like, for instance, like commandeering skiffs to go and pull scabs off of steamers that are docked out ashore, because if they're docked on the docks, they will get attacked and beat up. One of the differences, and there have been several labor historians who've written about longshoremen, is that, and this was the case in Baltimore, they're not nearly as roughly treated by the police. They're certainly arrested, but they're not nearly as roughly brutalized by the police, who in broad daylight would beat black longshoremen and stevedores while arresting white longshoremen and stevedores and subjecting them to police violence. But this is something that I'm thinking about broadly in the Mid-Atlantic for my next thing.
This is a wonderful talk. I want to thank Michael Casiano. Great. Thank you. And I want to thank all of you for coming and supporting Baltimore history. I know you'll be back. I want to encourage you to be back in January next year when we start up again. Consider the History Honors event and think about Baltimore history. Thanks very much.
Go out and make some history.
Thank you.
Yeah.